Last week there was a helpful amicus brief filed by, I think, the Family Freedom Project, where they argue that this should be a strict scrutiny, like constitutional analysis of what limits exist here for DFPS. And I'm just wondering, does this new provision that will be added to our Bill of Rights, I think as of this week it's been canvassed and is now part of our Constitution, presumably it will be Article 1, Section 37, does that govern what we do in this case in looking at the constitutional question?
Justice Sullivan, I don't know that it changes much. I think that the court has said in so many words, strict scrutiny has applied since at least 1987 when it issued the Boyd case. And there was narrow tailoring here. The mother had to get a psych eval because she has tremendous anger problems, evidenced by her outburst at Walmart at the school official that filed the DFPS report only because her child had approached her with that information. So, having to perform a psych eval, having to do anger management, those kinds of things are narrow tailoring. And the department does its best to make sure that
Are you agreeing that the strict scrutiny analysis should apply to parental termination cases?
I don't know that strict scrutiny is the right way. I mean, I think that the court has said they have to be strictly scrutinized. That's in the Boyd case and other cases. But if you're looking at a constitutional strict scrutiny analysis, usually you're looking at invalidating some statutory provision. I don't know that it makes sense to apply that to every action that the department has to take to ensure the welfare of the children.
The reason that I'm asking about it, and if you don't have the text of this new provision in front of you, that's fine, but the whole kind of tiers of scrutiny thing that we've taken, I guess kind of borrowed from our federal counterpart, from the early part of the last century. We do tiers of scrutiny, and maybe it's strict, and maybe it's intermediate, or maybe it's rational basis, or maybe it's rational basis with teeth. But now, instead of us putting it into an opinion, we have this text that'll be Section 37. Do the tiers of scrutiny make sense anymore now that it's been codified by the people of Texas in our charter?
I'm not sure, Justice Sullivan. I'd have to maybe think about that. And again, I'm not familiar with the provision. I'd be happy to provide supplemental briefing on that question if that's
well, our
appropriate.
court has long recognized a constitutional dimension to these termination cases.
Yeah, I don't see.
And although we didn't find a place in the Constitution to hang it, a hook, now we have one. But we've always recognized that there's a constitutional dimension to these cases.
Absolutely.